It's now my great pleasure to introduce, I'm going to get into trouble with this from my colleagues. I'm a journalist in my other life, and I write about the Supreme Court, but I have no doubt that Adam Liptak is the dean of Supreme Court journalists, one of the most thoughtful and illuminating people writing about the Supreme Court. Please join me in welcoming Adam Liptak.
It's great to be here on Freedom Day, whatever that is.
It's a celebration of freedom, as you know, because you just participated in a great podcast about this with Jeff Stone downstairs in our podcast studio.
And I salute Jeff Rosen, who has managed to sell our founding document and sacred text in the mode of an infomercial.
Well, it's an easy sell because it is such a great product, and that is freedom. So we have a lot to talk about. There is a big Supreme Court vacancy, I've heard, and the future of the Supreme Court may be altered by who fills it. And I want to think with you about how a new justice will and won't change our Supreme Court's approach to free speech. The First Amendment is interesting here. On the one hand, as you've written so eloquently, we have a series of unanimous or nearly unanimous decisions in which liberal and conservative justices have united to protect severely unpopular kinds of speech, ranging from protests at the funerals of soldiers to animal crush videos. And these are 9-0, 8-1 decisions. Tell me, how did this unusual coalition between liberal and conservative justices come to exist, and in what kind of cases do we see it?
We're at a moment in time where everyone's concerned about 4-4 deadlocks on the court, and everyone thinks the court is always a 5-4 court. In fact, the Supreme Court is unanimous a lot of the time, and including in important cases. And the cases you just mentioned, Jeff, and some others, are examples of that. There are commitments that we as Americans have and that the Supreme Court justices share, and one of them is to protecting unpopular speech, even if it's offensive, loathsome, unless it falls into one of a narrow band of categories. Unlike Facebook, the United States government allows all sorts of speech, and including things as hateful as someone protesting at the funeral of a fallen Marine while the family is grieving. The Supreme Court almost unanimously, in an opinion by Chief Justice Roberts, says we have to put up with that because our commitment to free speech is so high. Similarly, in depictions of animal cruelty, who's in favor of that? In violent video games, in allowing people to lie about whether they'd received a medal, the kind of medal that people have bled and died for. The Supreme Court says we're going to protect that speech, and that's an example of this 18th century document continuing to be a vibrant and forceful and muscular protection of a kind of commitment to free expression that is really distinctively American. You go as close as Canada, and certainly in Europe, they have a wholly different view about the kinds of speech to protect.
Great. So as you've described, this is a glory of the American constitutional tradition, this bipartisan consensus around the importance of protecting unpopular speech. And yet, there are also a series of 5-4 cases of the kind that people focus on, where liberal and conservative justices disagree sharply about the meaning of the First Amendment. And those include cases involving campaign finance, commercial speech, and union speech. I don't know if you want to take them in turn, but let's begin with campaign finance. What is the nature of the disagreement between the liberals and conservatives about what the Constitution means, and what are the battles that are on the horizon?
So let me step back for just a second. I'll focus on that. But the big picture is that free speech used to be kind of a universal project, but basically a left-wing project. Basically, liberals loved free speech. They wanted to protect the war protester, the hippie, the flag burner, and conservatives were wary of this. But conservatives gradually got the idea that free speech values could do a lot of work about the things they cared about a lot, including campaign finance deregulation, including protection for commercial speech, and including weakening the power of unions. And to start with the first, if there's one case that everyone knows that the Roberts Court decided, it was Citizens United in 2010. It's vastly unpopular with the American public, and yet it does something that in one sense is at the very core of the First Amendment. It says you can't make it a crime to talk about politics. What was at issue in Citizens United was a documentary about whether Hillary Clinton back in 2008 was fit to be president. It was to be presented on video on demand, and a federal law made it a crime so to distribute it. That may be a good idea, maybe a bad idea, but it's an extraordinarily hard First Amendment question about whether we're going to criminalize talk about politics. The court took the opportunity, could have decided more narrowly, but took the opportunity to make a very broad statement, saying that so long as the expenditures were uncoordinated with the candidate, so long as corporations and unions want to spend money to make statements pro or con candidates, they could do so in unlimited amounts, so long as not coordinated with the candidate. And the liberals on the court said, yes, we acknowledge there's a First Amendment value here. We acknowledge even, people tend to overlook this, that corporations have free speech rights. But we think the balance is off. We think this will so distort politics and so give rise to corruption or the appearance of corruption that we're prepared to regulate it.
If Merrick Garland or another appointee of a Democratic president is confirmed, will Citizens United be overturned?
It's certainly something that the next president, if a Democrat, would want Merrick Garland or whoever the appointee is to do. My instinct is that we would not see further expansion of campaign deregulation, and we would see Citizens United in some of the subsequent cases rolled back, but incrementally and slowly, and you would have to have cases in which to do it. So that requires some litigation strategy as well. But I think the needle would move in the other direction. It wouldn't move nearly as dramatically as Citizens United itself, which overturned two major precedents, one of them quite recent, and was a much bigger decision than you had to do. If all you wanted was for this documentary that I talked about a second ago to have been protected, there were countless ways the court could have ruled in favor of the documentary without making the broad sweeping statement. But the short answer is, I would expect this area to start to be rolled back if a Democratic appointee were successful.
And given the fact that Congress is unlikely to repass the kind of regulations that were struck down in Citizens United, would it make much of a difference if Citizens United were overturned or rolled back?
I think probably not in the short term if Congress looks anything like what it looks like today at the federal level. But there are state elections too, and I could imagine state legislatures passing laws that would restrict campaign spending. And I think if one of those cases were to get to the court, it would reshape the doctrine.
What about commercial speech? This is another area where liberals and conservatives disagree a lot. You've written that the Supreme Court's effort to protect the interests of corporation is part of a broader sympathy for business interests. Tell us about that and what kind of regulations are going to be at issue as the court moves forward.
So the history in this area is once upon a time, the First Amendment was thought to protect political expression, mostly, maybe artistic expression, but business transactions, commercials, were outside the scope of the First Amendment, it was thought. And then gradually in the 70s, commercial speech got some protection, basically as a consumer protection matter, because drugstores would get together and get a law passed saying you can't advertise drug prices, so that they could, in a monopolistic kind of way, keep away from consumers the ability to shop around on price. And gradually, and this was a left-wing project, commercial speech protections came into existence, and the court said, we're gonna scrutinize these, but not very closely. Lately, what we're seeing at the Roberts Court, and this is the result of a long-term conservative project, is it's starting to look like we're going to treat commercial speech the same as we treat all other kinds of speech. And there was a little noticed, but probably profoundly important decision last year called Reed against Town of Gilbert. The case itself was trivial. It was about how big a church's signs could be. But in the process, Justice Thomas, writing for the court, said, the court now will view any content-based restriction. And content-based restrictions is, securities regulation is a content-based restriction. Food and drug labeling is a content-based restriction. Pharmaceutical advertising is a content-based restriction. We're going to view all of that the same as all other speech. We're going to think that it's presumptively unconstitutional, and we're going to subject it to the most searching kind of First Amendment scrutiny, which typically means it will fall. And if the Roberts Court is to be taken at its word, and when I speak of the Roberts Court, I guess I'm speaking in the past tense, because the next justice will profoundly alter the court in whatever direction. We've had a 10-year run from when Justice Alito came onto the court in January of 2006 to when Justice Scalia died in February, where the court has really been united on these First Amendment issues. That also happens to be almost exactly the period when Clarence Thomas didn't speak. But I expect the landscape to look different. So when we're talking about the Roberts Court, it's a backward-looking thing. But the old Roberts Court made this statement, and if taken seriously, it could subject all kinds of ordinary regulation to exacting First Amendment scrutiny. Tobacco advertising, pharmaceutical advertising, whether people can be made to disclose what's in their juice, whether people can be made to disclose whether they did business in a certain part of the world. So it's a very radical statement, and it may be that because we have now an 8-member court and soon a different 9th member, we'll have some different answers.
So how far could this go? Eugene Volokh, who I showed is a writer on our interactive constitution with Jeff Stone, wrote a really interesting white paper for Google saying that because Google's algorithm is free speech, any regulation of Google with antitrust laws would violate the First Amendment. Might that continue under a new court, or would it reverse? And I want you to play some baseball here. This is not a totally liberal and conservative thing. Justice Sotomayor has joined the conservative justices in encouraging high protection for commercial speech. Is it clear that a Merrick Garland, for example, would, which side would he be on?
Well, you're right to say that this is not a 5-4 area, it's a 6-3 area. So the two leading cases, the Reed case I mentioned, and another case called Sorrell, are both 6-3, the conservatives plus Kennedy plus Sotomayor. So a single justice might not make a difference. You're right about that. I think these are issues the court struggles with. There have been political science studies, and this is really not what you want to hear, but that they tend to protect speech they like, and they tend not to protect speech they don't like. So while you would hope these are neutral principles applied by, demigods without respect to who's doing the speaking, it turns out they mostly help their team.
How do you reconcile that with this protection for the hate speech at funerals and so forth that you began with?
I think those cases are in their way minor, are teaching opportunities to say to Americans, listen, on a one-to-one level, put aside corporations, put aside when someone is in your neighborhood talking, you should let them talk. And if you have that impulse, which all of us do, to try to censor the stuff we don't like, if you're the school librarian and you might be inclined to throw some book out because you don't like what it says to the American public, this is a core tenet of the American commitment that we believe in free speech.
Hate speech on campus. There are great pressures, as we'll see in this incredible panel following this one with the leading thinkers on this topic, on campus to restrict hate speech. To give just one example, at the University of Oklahoma, there were pressures to expel some students who were caught on video making racist comments. And on campuses, there seems to be growing support among students for a vision of dignity and equality that's very different from the traditional Brandeisian First Amendment that we were talking about in the first panel. When one of those cases gets up to the Supreme Court, if it does, well, will it? And then if it does, which way will the justices go?
Right. So maybe we'll make a quick distinction here between two kinds of universities. Public universities, universities run by the government, are subject to the First Amendment. The First Amendment protects the government from censoring people. And if such a case were to come up from a public university to this, or I would say any future Supreme Court, that court would not allow punishment of hate speech, unless it fell into one of a few very narrow categories. Fighting words where you say an insult to someone's face and they punch you in the nose. Or a true threat directed to a particular individual, not a group of people, not anti-Semitism or racism, but a threat directed to a particular person, or incitement of imminent unlawful action. So having reeled off all those things, those are not what we're talking about in Oklahoma. And I'm confident that the Supreme Court would protect hate speech. America is alone in the world in protecting hate speech. The rest of the world can't understand what the hell we're thinking. And where you started, Jeff, was, is there a change in mood on campus? I think absolutely yes. I think the new generation is much less tolerant of ugly speech, much more apt to welcome stifling that speech. It's perfectly understandable. In order for people to feel they're part of a community, they need to feel they can speak to each other without being demeaned. And yet, the First Amendment at least gives us a different answer. The First Amendment tells us that the response to ugly speech is counter speech, as you suggested, Justice Brandeis would have it, that it's not to shut up the other person, it's to reason with him or her, it's to draw the community together and to educate one another in an academic environment. But I don't think that's where many young people are today, and I think it's quite different from when you and I were on campus, when it was much more accepted across the political spectrum that free speech was a value that requires us to put up with a bunch of offensive speech.
When I was in law school, a bunch of us protested the right to engage in hate speech. That was, a civil libertarian sort of dogma. Nowadays, things are different. You are teaching at Yale now. You are seeing these students. Why have things changed?
I think it's partly the consequence of social movements that most people would think are to the good. The women's movement, the civil rights movement, the gay rights movement, which have brought into the open groups that have long been disfavored and who had to put up with a lot of nonsense. And now that they're full-fledged members of the community, they don't want to be demeaned and they don't want to feel uncomfortable. And I understand those impulses. I think that's quite right, and civilized people should not, demean each other with hateful speech. But if the alternative is for the government or for a powerful institution to censor the speech, I think we're worse off. Nobody's in favor of ugly speech, but it's much better to address it, or at least the First Amendment, the traditional American conception of the First Amendment would have it, is to engage it, not to censor it.
I have heard it suggested that the Brandeisian traditional First Amendment is under assault from populist forces ranging from these students on the left to Donald Trump on the right. Is that fair?
I was very surprised to hear Donald Trump, who doesn't seem to be a legal scholar, describe how he would like to, and he didn't quite explain how the president would do this because it's a constitutional principle, but he would like to rewrite the libel laws to make it easier to sue people who say bad things about him. And that again, that's at odds with how we do things. And so it's not confined to the left, but I think as a general proposition, to repeat myself a little bit, but in a slightly new context, conservatives are more committed to free speech values across the board, I would say, than liberals are for some of the reasons we've been talking about.
Protests, they're not like they used to be. President Clinton was just shouted down in Philly. From Trump rallies to Clinton rallies, the effort seems to be to exercise a heckler's veto. Legally, what do you make of this? Might the Supreme Court get a protest case? And practically, as a debate impresario, what should I do if someone tries to shut down Freedom Day?
Is the Constitution Center a public or private organization?
Ladies and gentlemen.
This is a complicated question.
No, it's not a complicated. It's a simple one. Ladies and gentlemen, potential donors to the Constitution Center, this is very important. We are a private nonprofit that receives little government support. We are an entirely private institution. We were created by Congress during the bicentennial of the Constitution and the Bicentennial Heritage Act. And we have this wonderful charter to engage in nonpartisan constitutional education. But it is complicated. A private nonprofit in a federally owned building leased to the Constitution Center for $1 a year for 100 years.
All right, so That's a good law school exam, and I'm not going to tell you how to deal with the heckler.
More broadly, though, the question of what university deans and presidents are dealing with this. What does the law say about hecklers' vetoes? Can someone stand up and try to shut something down consistently with the First Amendment? And what's the Supreme Court likely to do when it gets one of these protest cases?
I don't think that the version of that case that comes to the court occasionally is the Secret Service hustles somebody out who is probably actually just a heckler, but after the fact turns out to be a security threat. And in those cases, but those are not the case you're really talking about, the Secret Service always wins. In general, a heckler is a kind of private censor, and you can take steps to avoid that, and certainly if you're a private organization.
My friends at universities think that disciplinary rules may be the best way to go, and if a student tries to shut down an event, discipline rather than the law might be a good response.
Well, discipline is a form of punishment too. When I talked about this with some students not long ago, several of them said, well, don't we sign a kind of actual code of conduct contract, or at least a kind of notional contract that when we come to a university, we're going to treat each other with respect, and if we don't do that, the university can discipline us or kick us out. And I thought that has some force, and I think in the private setting it's probably valid, but it's a dangerous business if you're at an institution that's committed to free and reasoned discourse.
Union speech, another fissure in the Friedrichs case. The court divided 4-4 just recently. It might have gone the other way if Justice Scalia were still on the court. What do liberals and conservatives disagree about the First Amendment and unions?
So this was a case where, but for Justice Scalia's death, public unions would have sustained a staggering blow. And here's the First Amendment argument. If you're a member of a public union, you don't have to join. Well, so let me back up. If you're represented by a public union, you're a teacher, you don't have to join it, but you do have to pay the equivalent of dues called agency fees. And even there, you don't have to pay 100 cents on the dollar. If the union is engaging in political activities, like putting up campaign ads for a presidential candidate, you don't have to pay for that, you can opt out of that. Okay, so far so good. That's been the legal landscape for 30 years. Comes this argument. We think every cent on the dollar, even that money which the union uses to pay for its collective bargaining activities, is a kind of political speech. Because when the union goes to the government to say, please pay us more, please have a certain kind of tenure regime, please increase our pensions, that's kind of a political act because it's a policy decision for the government to decide what it's going to do in those areas. And that argument got a lot of traction at the Supreme Court. A couple of years ago, they almost said, that's right, if public sector union workers don't want to join, they don't have to pay a penny. And that would have been really tough on unions. And when this Friedrichs case was argued in January, it sure looked like there were 5 conservative votes to deal a blow to public unions in this way. And then after Justice Scalia died, the court announced that it had deadlocked 4-4. That means it issues no opinion. The opinion below, there's no Supreme Court precedent. The opinion below stands. And in this case, the opinion below was a victory for the unions. So the net effect of Justice Scalia's death in this area was, 1, that unions dodged a bullet, and 2, that a pro-union decision in the court below stood.
I want to ask you about Chief Justice Roberts. His power as Chief Justice is to write the majority opinion when he's in the majority, or assign it to the justice he thinks will best reflect his views. We face the prospect, if Justice Scalia is replaced by a liberal justice, of a Chief Justice who may not be able to command majorities in 5-4 cases. What for the first time since the 40s, when under Stone the dissent rates started to go up, even then he had the majority of 5-4s. Is this the first time that the chief might not be able to command the court in close cases?
Yes, but you're assuming that the chief's voting stays constant in the new world, or perhaps he thinks it might be worthwhile to be in the majority even at the expense of shading his views a little bit. And because the assignment power for the Chief Justice is so important, there's some reason to think, and we're already seeing a little bit of this, perhaps for other reasons. Roberts has trended left, Alito has trended right, Kennedy's trending left. So there's some movement among them. And most political scientists would predict that Roberts moves further to the left to the extent the balance of power on the court shifts to the left for the reason you suggest.
Wow, how interesting. So then take us, imagine it's 5 years ahead and there's a solid liberal majority. How does the First Amendment look different, and which side is Roberts on?
Well, we've seen Roberts. I should say the chief is very interested in these issues. He's very fair about assigning majority opinions. He doesn't always take the good ones. But he self-assigns First Amendment cases at twice the rate he self-assigns other cases. It's an area he's deeply interested in. But we've already seen at least 2 instances where, in First Amendment cases, he has gone a little more liberal than you might expect. In one of them, he joined only for the second time in the history of the Republic in a 5-4 case, the 4 liberals. The first one was the first Affordable Care Act case, a case in which the question was, can you limit judicial campaign speech? Can you tell judges that they may not personally solicit money from people who appear in front of them? That may strike you as an easy question. For the court, it was hard. It was a 5-4 decision, the chief plus the liberals, but comes to a liberal conclusion. Similarly, there was a question about buffer zones outside abortion clinics. Can you limit speech around abortion clinics as women try to go in, in this very difficult time? And some of them accosted by protesters, some of them by more quiet counselors. And there, although the court was nominally unanimous, the chief plus the 4 liberals found a way through that thicket to strike down that particular buffer zone, but leave other possibilities open.
So how does that look in the future? Does that mean rather than a clean overturning of Citizens United, he might move with the liberals to make it slightly more permissive, but not entirely? What does it look like?
Well, we know a couple things about the chief and Citizens United. We know that there was a precursor case in which some similar issues were presented, and he wanted to take an incremental step and did, causing Justice Scalia to accuse him of faux judicial minimalism.
Fighting words on the Supreme Court.
And then Jeff Toobin reported, and I think persuasively, that when Citizens United was first argued, the Chief Justice had tried to write a similarly incremental, smaller decision and couldn't get the votes, was set down for re-argument, and then Justice Kennedy, for whom this has been a long-standing project, took the majority opinion. So there's some reason to think that this is not the issue he lives and dies on. There are counterexamples. The McCutcheon campaign finance case is a counterexample. But that whereas he'd been marching minimally in incremental steps to the right, it's conceivable that if he's heading a court that has 5 liberals on it, he might want to march incrementally to the left, but maybe taking small steps.
Justice Kennedy, I hope this isn't too inside baseball for everyone, but it's fascinating. I'm learning, and I want to ask you about Justice Kennedy. He's a passionate defender of the First Amendment, both for the free speech interests of individuals and businesses. Under a liberal court, he's no longer in the driver's seat. Does the First Amendment become narrower as a result?
I don't have an elaborate answer for that. I just think you're right.
Excellent.
Justice Kennedy is typically said to be the swing vote, and he is in most cases at the ideological center of the court, or used to be when it was a 9-member court. But on First Amendment issues, he's got the most expansive vision of the First Amendment, and is not in the middle. And I think you're right that if there were 5 liberal votes, I mean, all of this needs to be grounded in actual questions and actual cases. It's very easy to talk about these abstractions. These are judges, after all, who will look at particular facts, particular doctrines, particular precedents, and try to do, good, lawyerly judicial work. But in broad strokes, you're exactly right.
What about the First Amendment changes if Justice Garland is confirmed?
Justice Garland, I was delighted to see, he hasn't written much in this area, but the 2 things that he's written were about the press clause. We haven't talked about the press clause yet. And the Roberts Court has not taken a single case on freedom of the press, which used to be very much in the diet of the Supreme Court. Basically, all they've said in Citizens United is if corporations have no First Amendment rights, neither does the New York Times, because it's a corporation too. Which by the way, that argument has a fair bit of force. But Garland has twice dissented in important press cases on the D.C. Circuit, once to stand up for the reporter's privilege, our ability to protect our confidential sources, which does not seem to have any support on the current Supreme Court. And I think he'd bring a fresh voice on the reporter's privilege. That would be fantastic. And once to speak up on behalf of the ability to publish truthful, newsworthy information that somebody else had obtained unlawfully and given to you. And that's an issue that is in flux on the Supreme Court and would be very nice to have Justice Garland's voice on it. So speaking as a matter of pure self-interest as a journalist, plus he's a nice guy, it would be lovely to see him on the court.
Truthful but embarrassing information, back to Brandeis. His vision in his original Right to Privacy article was that you could restrict the publication of truthful and embarrassing information if it violated honor or dignity. Later on, he changed his mind and came to believe that judges shouldn't be in the business of deciding what people should listen to. Can you imagine future progressive justices favoring the early Brandeisian view and allowing the restriction of truthful but embarrassing information if it violates dignity?
You call it the Brandeis view, I call it the Hulk Hogan problem.
Tell us about Hulk Hogan. That's much more highbrow.
So in the digital era, it becomes a little harder to justify what is my impulse, is to say if a news organization decides that some embarrassing fact about, say, a public person, in Hulk Hogan's case, a sex tape, is of public interest, then basically we win the privacy suit. If it's truthful and newsworthy, we win. And newsworthy, I always thought, I used to be an in-house lawyer at the New York Times Company, I always used to thought, well, if it's in the New York Times, it's newsworthy. We decided it's newsworthy. It's worth being in the New York Times. I think now it's a little harder to know where people go on this, and I think this is an area where the court might get a little soft on protecting speech or balancing speech against privacy.
The biggest clash between privacy and speech today is over the European right to be forgotten. It comes from the French droit à l'oubli, or the right of oblivion, which is extremely French. And the idea is that if you are in Europe and you object to the publication of any truthful but embarrassing information about yourself on Google or Yahoo or another search engine, Google has to remove it unless it determines that it's necessary for public discourse or in the public interest. And if Google gets it wrong, it's liable for fees which could be as high, if a new European law passes, of up to 4% of its annual income, which last year I think was more than $60 billion. That's a good gasp. So, Adam, right now, America takes a very different view, as we just described on the previous panel. Could you imagine future progressive justices moving in that European direction?
You know, I could imagine a future progressive justice who put something up on her Facebook page when she was 19, maybe taking a different view. I do think we live in a different world. It used to be that you'd do something stupid as a kid, and maybe it turned up on page B16 of the newspaper, and it couldn't be searched or found by, your friends or potential employers or whoever else. Now that digital trail is forever. And it may be that causes the scale to shift a little bit. In a different context, the court has talked about the value of practical obscurity, which is not to do away with something entirely. But you don't have to make it the first search result when you're, a 50-year-old person about somebody who did something at 18. I mean, we have this question at the Times a little bit, where we reported way back when that somebody was arrested for a crime, a minor crime. And maybe we never even followed up with a subsequent article about how that person was acquitted. And yet they have an unusual name, and it turns up first on the search results at Google. I think that's an authentic problem. I'm still on the side of speech, but I think it's an authentic problem.
Okay, it's time for closing arguments in this great conversation. Will the Brandeisian First Amendment that we've been describing survive in 30 years, and should it?
Yes and yes. The Constitution is the sacred American text for a reason. It reflects who we are and what we believe. And while you can, shape the edges a little bit, the core commitment to free expression is so much part of the American identity that if it were not to survive, we would be an entire nation and an entirely different culture.
Ladies and gentlemen, please join me in thanking Adam Liptak.
Thank you, Jeff.